The Supreme Court reconvened today with a full bench for the first time since Anthony Kennedy retired in July. Brett Kavanaugh cemented the court's conservative majority as the justices heard oral arguments for a case that asks which felonies count as violent when it comes to criminal sentencing. And other cases on the docket may have an even broader impact, like a class action suit that asks how quickly DHS needs to start deportation proceedings against immigrants with criminal records. The lead plaintiff, Moni Priap, became a lawful permanent resident in 1981, but he was picked up by immigration authorities in 2013, 7 years after he served time for a misdemeanor marijuana possession charge. DHS said that since Priap's drug conviction was a deportable offense, he was subject to mandatory detention, meaning they could hold him in immigration jail indefinitely without bond while his deportation case played out. Nielsen v. Priap, which will be argued tomorrow, asks if immigrants who've served time are exempt from mandatory detention if DHS doesn't take them into custody immediately after they complete their criminal sentence. Russell BUCKLEW was sentenced to death in Missouri for murder, kidnapping, and rape. Missouri executes prisoners by lethal injection, the most common execution method in the U.S. But BUCKLEW was born with a rare medical condition that covers his head, neck, and throat in blood-filled tumors. He argued that an injection could make the tumors burst, causing him to hemorrhage and potentially choke on his own blood, and asked to be executed in a gas chamber instead. BUCKLEW v. PRECYTHE asks whether the Eighth Amendment, which bans cruel and unusual punishment, grants death row inmates the right to prove that a certain execution method would be unconstitutionally torturous. It'll be argued in November, 3 weeks before another Eighth Amendment case, TIMBS v. Indiana, which is about something called civil asset forfeiture, a tactic that lets cops seize property they say was involved in a crime, including money, real estate, and cars. Like a Land Rover owned by Tyson Timbs, who was convicted in Indiana of felony drug dealing. The Land Rover was worth more than 4 times the maximum fine for Timbs's crime. But the Indiana Supreme Court said the seizure was legal under state law, and that the Eighth Amendment's ban on excessive fines doesn't clearly apply in every state. The federal government took nearly $5 billion worth of property via asset forfeiture in 2014, sometimes even without evidence of wrongdoing, and states took hundreds of millions more. If Timbs wins, it could curb the practice across the country. Arguments haven't yet been scheduled. In 2011, a group of iPhone buyers claimed Apple had an unlawful monopoly on iOS apps. They argued that by forcing iOS users to use the App Store and by taking a 30% cut from app developers, Apple passed inflated costs onto consumers. In Apple v. Pepper, which will also be heard in November, the justices will decide whether the iPhone buyers are even able to sue Apple for this alleged monopoly in the first place. Only direct purchasers can sue under antitrust law. And Apple claims that users actually buy apps from developers, not from Apple itself. The ruling could affect how much power consumers have over tech giants.